Did you understand in count 1B, you're charged with the offense of assault intentionally, knowingly, serious bodily injury to a child? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Little Mercedes LaSoya died because of the horrific actions of her mother and her boyfriend. San Antonio police say the 5-year-old had visible bruises, scratches, cuts, and swelling on almost every visible part of her body. Today, her mother, Katrina Mendoza, in court to accept a plea deal. According to that deal, she won't be sentenced to more than 45 years in prison. Before a judge, she pleaded guilty to assault, to intentionally or knowingly causing serious bodily injury to a child, her own daughter. It happened last year. Back in February, Mendoza took her daughter Mercedes to a hospital after she became unresponsive. Hospital staff tried to revive her, but she died. Homicide detectives then launched an investigation and found evidence that linked Mendoza to her injuries. SAPD's investigation also led to Mendoza's boyfriend, Jose Angel Ruiz, being arrested and charged as well in his case. Now,
State of Texas versus Katrina Mendoza. Can I have parties announced for the record for the state?
Brittany Mitchell and Marissa Giovenco for the state.
Defense?
Good morning, Your Honor. I'm Todd McCrae for Katrina Rose Mendoza.
And are you Ms. Mendoza?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Ms. Mendoza, I'm showing you what's entitled application for deferred adjudication. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are proceeding under count 1, paragraph B, and waiving the remaining counts, Your Honor.
All right. Any objection to the waiver of count 1? Excuse me. Any objection to the waiver of count 1, paragraph A, count 3, count 2, count 4, and count 5?
No, Your Honor, that's per our agreement.
Ms. Mendoza, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand in count 1B, you're charged with the offense of assault intentionally, knowingly, serious bodily injury to a child? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to life in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does. I've reviewed everything thoroughly with her, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Mendoza, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived jury trial. Going to show you what's entitled plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am, I did.
All right, off the record for a moment. All right. So, Ms. Mendoza, paragraph B is assault intentionally, knowingly, serious bodily injury to a child by omission. You understand that
Yes,
is
ma'am.
the offense that you're pleading to?
Yes, ma'am.
All right. So, with regards to the plea bargain agreement, your punishments be assessed at a cap of 45 years. The state opposes your application for deferred adjudication, and there's an affirmative finding of family violence. And also, there is a plea bargain agreement that is attached. And was that attachment filled out today, State Defense?
Yes, Your Honor.
All right. So with regard to your plea bargain agreement, there's an affirmative finding of family violence. What that means is that you're not allowed to own or possess any weapons or ammunition. Did you understand?
Yes, ma'am.
And did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
And did you understand as a part of your plea bargain agreement with the state that your sentencing will be postponed until the completion of the trial of Jose Angel Ruiz? Did you understand that?
Yes, ma'am.
And did you understand that if you fail to comply with the terms of this plea bargain agreement, that your plea that you enter into, whether you plead guilty or no contest, that plea will stand. And if it's determined that you fail to fulfill your obligations under the agreement, you will be subject to the full range of punishment. Do you understand?
Yes, ma'am.
And that full range of punishment is up to life in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes.
Next, I'm going to show you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Your Honor.
Then to count one paragraph.
Other than in discovery, we ask for discovery of the phone and the contents of the phone. And the state's response was that the contents of the phone, that's the co-defendant's phone, is still being extracted because there's you might remember the hearing. There's a code there that they haven't been able to break.
All right, and I believe that's, if I'm remembering correctly, I believe that's the case where the defendant offered to.
Right.
Give us code.
I'm being told we just got a cell phone
believe we just got the
download
second
in,
cell phone download.
so we can provide that to defense counsel.
All
Very,
right.
very good.
So,
It may have already been uploaded, to be honest. I've already given it to them to be uploaded, so I will double check on that.
all right, Ms. Mendoza, you understand that there's a cell phone dump from the co-defendant's phone?
Yes, ma'am.
And were you aware of this before entering this plea? That there was a cell phone?
Yes.
And were you aware before entering this plea that the state did not have the contents of that cell phone to turn over to your defense counsel?
Yes.
All right. The state has informed the court that that has been completed. Do you still wish to continue with this plea?
Yes.
And are you waiving your right to have the contents of that phone viewed before entering this plea?
Yes.
Defense, is that correct?
I concur.
All right. But even with that being said, state, you're going to provide that information to them?
Yes, absolutely, Judge.
All right, then to count one, paragraph B, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Your Honor, we offer State's Exhibit number 1 and all attachments.
Which I've reviewed thoroughly with Ms. Mendoza and we find no objections.
All right, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court is going to find there's sufficient evidence to find you guilty. Court will defer finding you guilty as you've applied for deferred adjudication. Ms. Ferguson, when is the co-defendant set for trial? October 3rd? All right, so the co-defendant's case is going to trial on October 3rd. And we will send this for a PSI. And we will be back. You will most definitely be back on, I want to say October 4th because we'll have jury trial on October 3rd.
Yeah.
So, Ms. Ferguson, let's just put this on the docket for, let me look at the calendar. You know, the computer did an update and the update is just changed everything around on the computer. So October 3rd, we'll probably do jury selection. So Norma, let's just bring this back on October 2nd to make sure that everything is still proceeding the way it's supposed to proceed. So we'll put October 2nd. And that's not the date you will have your sentencing. According to your plea bargain agreement with the state, your sentencing will take place after the co-defendant's jury trial. Do you understand?
Yes, ma'am.
So we're going to bring you back. We can go off the record. We're going to bring you back on October 2nd. Probation on Mendoza, I'll need a PSI done. We're going to bring her back on October 2nd, but the actual sentencing is not going to take place until after the co-defendant's jury trial. All right, so we'll bring you back on October 2nd to see where we are with the jury trial, but the jury trial should be proceeding on October 3rd.
And one final thing, Your Honor, if I
Yes.
may. So you could see that Ms. Mendoza's status right now, because she's dressed in red, is pretty much what they call isolation.
Yes.
She's isolated. She only gets 1 hour to be outside of that isolation. We would ask the court respectfully if the court would review her status. If she is classified as protective custody status, she gets a few more hours out of the isolation. And I know the court knows this, but she also could participate in classes and things like that. So our plea would be to ask the court to review her status at the jail. And we would respectfully ask the court to classify her as protective custody rather than the isolation she's in.
All right. Well, what I can tell you is we've had situations of this nature before. It would be best so that I won't have any responsibility if something were to go awry. I'm not saying it would, but if you will reach out to the sheriff or to classifications and let them know you would appreciate her being reclassified, they will usually do that. But they're going to want it in the form of a letter from you signed by your client.
Okay, so you think a letter to the sheriff's classification requesting protective custody might do it?
Yes. And then if that doesn't happen, we can always come back and have a hearing on it.
You understand, Ms. Mendoza?
Yes.
Thank you, Your
All
Honor.
right. You're welcome. Is there anything else?
Nothing further from the state, Your Honor.
All right. Thank you.
Thank you, Judge.
Man accused in the death of a 5-year-old girl last year is now headed to trial. 5-year-old Mercedes Lasoya's mother was charged in the girl's death and took a plea deal in exchange for testimony against her boyfriend, Jose Ruiz. Jury selection for Ruiz's case will start December 12th. He could spend the rest of his life behind bars if found guilty.